Our speaker for today's subject is Mike Branley. Mike began his auction career in 1979. He is president of Branley & Associates, Inc., and is an associate and auctioneer for Keller Williams Greater Columbus, a large real estate brokerage based in Columbus, Ohio. He is a graduate of the Certified Auctioneer Institute and also holds the NAA Accredited Auctioneer of Real Estate, or AARE, designation, as well as the CAGA appraisal designation. In addition to all of that, Mike is also an instructor for the National Auctioneers Association's AARE designation program. Now, before he begins, please note that you may submit questions at any time during the presentation. These questions will then be asked during our brief Q&A period following the conclusion of today's presentation. You can take part in the conversation by typing your question and submitting it. A little later, we will also ask that you please take part in a very short 3-question poll toward the end of the presentation as well. With that, we are extremely pleased to be joined by today's presenter. Mike, the floor is yours.
Thank you, Curtis. Mike Branley here. Good to have everyone joining us here on a nice afternoon. More and more real estate is being sold at auction. I think we may be attaining record levels here in the next year or two. We're getting out of the recession. People are more confident. So legal issues regarding real estate auctions will be pertinent to more and more of our members and auctioneers around the world. Our conversation today involves, well, where do we find, answers the question hopefully, where do we find the laws or regulations that come into play regarding current real estate auctions, the real estate auction business. And basically, as you see here on this slide, almost everything an auctioneer needs to know about real estate at auction in terms of remaining compliant and in concert with the law and limiting liability lies in one of two places. One is the UCC 2328, and two, decisions that the Supreme Court of the United States has made. Regarding our first section of law here, the UCC 2328, it was the work on the UCC 2328 started in the 1880s. It was finally adopted by every state, literally, minus Louisiana, by analogy, as we say, by the early 1960s. And the UCC 2328 deals with things such as each property is separate, what the fall of a hammer means, reopening the bid, with or without reserve auctions, withdrawal of property, retraction, revival, to what extent can the seller bid in what circumstances. What it doesn't answer are these two questions here. Does the UCC 2328 apply to real estate auctions, and does it apply to online auctions? And the answer in both of these cases is yes. Regarding number one, the courts in a uniform fashion across the United States have consistently said that these same rules that are prescribed in the UCC 2328 apply equally to real property as they do personal property. And number two, do they apply to online auctions? And again, the answer is yes. The courts again have been uniform. There's been a slightly less case law here, but to the extent that we've had it, the courts have said it doesn't make any difference if you're having your auction online or live or simulcast. The UCC 2328 applies to that as well. The other area of law, more interesting to auctioneers, is what the Supreme Court of the United States has said. We sometimes say the United States Supreme Court, but officially the Supreme Court of the United States. You can see a current picture of our Supreme Court there on the right. And any time the U.S. Supreme Court makes a ruling, it affects all auctioneers certainly within the United States, and sets some precedent for even other countries' laws and procedures and customs. So what the Supreme Court says is very important, and they've only, you might say, only commented about real estate at auction or auction cases at all 3 times. It might occur to you, well, gee, that seems like a lot that they've seen 3 cases, and on the other hand, gee, there's only been 3 cases. Why aren't there more? Our first one here, Vesey v. Williams, an auction took place in 1836, and it took until 1850 to reach the United States Supreme Court. It's known as Vesey v. Williams. It's one of the most famous auction cases of all time. Mr. Vesey here is suing Stephen and the issue was that the auctioneer, Henry Head, happened to be his name, Mr. Vesey's bid at $20,000. Now this was 1836, it'd be like $15 million today, on some real estate, and took the bid all the way to 40 by placing what the Supreme Court called fictitious bids, bids that weren't really there. The auctioneer, Henry Head, testified that he had knowledge that Mr. Vesey would keep bidding, and so he was going to make sure that he increased the bid for his seller, working for his seller in this case. The court ruled that the buyer, Mr. Vesey, was due one of two things. He could either be refunded the difference between his last legitimate bid and the final bid, or he could void the transaction altogether. And for you folks that study the UCC 2328, that's almost the identical language that was then adopted into all 50 states some 30, 40, or 100 years later. So this is a landmark case in terms of that you can't take fictitious bids or can't take bid, and secondly that it was the precursor to our law as it stands today. We got the next one there. There it is. Jackson v. Smith, another auction related case, and this case involved a receivership. For those of you in that business, bankruptcy, receivership, courts appointing receivers, and receivers working for court to maximize for creditors and that type of thing. And this case, as you look at the parties here, the plaintiff and defendant, Jackson was the subsequent or follow-up receiver suing the previous receiver, Mr. Smith, and there were others involved, but it's known as Jackson v. Smith. What happened in this case, the Supreme Court heard that the facts, which were that Mr. Smith and some other parties were selling some real estate at auction and had a buyer off to the side, kind of in their pocket, and didn't inform the court of that, sold it at auction, and then a few days later sold it to this buyer and realized a substantial profit. And the subsequent receiver sued the previous receiver for that realized profit. And the result, important to us today here, is the United States Supreme Court said that we represent the seller. We represent the seller. We have to represent the seller. It also suggests that in most states, if not all states, it would be difficult, if not impossible, to be a dual agent. In other words, at a real estate auction, you have to represent the seller, or more so, you can only represent the seller. You can't represent yourself or represent a buyer. So this case, of course, comes in today. We have auctioneers that say, you know, I was bid calling and I bought a house, or I represented myself in a real estate auction deal, or what have you. And the Supreme Court would suggest that representing the seller is the only option. Our last one here, Mottram v. United States. The only difference between this case and the other two is this did not strictly involve real property, involved personal property, what's known as Garlock packing. The auction didn't take place in the United States. It took place in England. J.G. White Auctioneers in London, England, conducted the auction. This was after World War I. But the case took place in the United States, and the court hinted that this as well would be the policy. Its final decision would be the policy for real or personal property auctions. So it applies to our details today. Mr. Mottram was interested in some, as I said, Garlock packing in a warehouse in London, England, and there was a catalog printed. The United States actually printed a catalog describing the garlock packing and describing that there was 278,000 pounds of it. Mr. Mottram went over and looked at the warehouse, checked in, and saw that, well, there isn't 278,000 pounds of garlock packing. There's about 2,000 pounds of garlock packing. Nevertheless, participated in the auction, was deemed the buyer for $9,000, and then demanded 278,000 pounds of garlock packing. Well, the United States said, we don't have it. We don't have it. We've only got 9,000. And he cited that the catalog said otherwise, and he wanted what was in the catalog, not necessarily what was in the warehouse. Well, the United States Supreme Court heard this case and said that since the property was selling, and the United States argued this, was selling as is, and that's a term that we all use probably all the time, that the as-is doctrine holds if the buyer has an open opportunity to preview and a reasonable opportunity to preview, and Mottram was deemed to have both. So he was forced to take 2,700 pounds of garlock packing for his $9,000, and the United States set in 1926 an as-is standard, which still applies today. So if we summarize this area, and it might seem overly simplistic, but in 2014 here, there are basically 5 important things to remember as a real estate auctioneer. Number one, that there are laws for the fall of the hammer, reopening the bid, with reserve, without reserve, retraction, revival, seller bidding, and those kinds of things for real estate auctions, live real estate auctions, and as you can see here, number 2, for online real estate auctions. The rules for bid calling, the UCC 2328, sale by auction as it's titled, applies to real estate auctions and it applies to online auctions. So it's important for auctioneers to be familiar with those 254 words in the UCC 2328. Number 3, auctioneers can't run the bid. You can bid for the seller if it's disclosed in a with reserve auction. You can bid, the seller can bid, or you can bid for the seller in an absolute auction if it's a forced sale, if it satisfies the forced sale doctrine. But otherwise, auctioneers can't take bids that aren't there under any circumstances, whether it be a with or without reserve auction. Number 4, we have to represent the seller. We have to represent the seller. We can't be entering into dual agency relationships or representing the buyer at the same time. And especially, I think it's important not to be bidding on property while bid calling or bidding on property online while offering it online, and those kinds of things for your own interest, for an auctioneer's own interest. And number 5, that we can sell property as is. And the live auction market, we've been familiar with this for centuries, but it opens up really some new questions in terms of online, because if we got a property in Maine and we got a bidder in California and we're selling it as is, the question becomes, is it open for preview? And it likely is, but is there what's considered reasonable opportunity to preview? I don't know that the courts have answered that yet, but we can sell property as is as long as we meet those 2 important criteria. So in summary, with more and more real estate being sold at auction and more people interested in researching, particularly online, about real estate at auction, it becomes paramount for us as auctioneers to be up on the laws and the rules and the regulations and the court decisions that affect that business, because if we're not up to speed on them, our sellers and our bidders and our buyers are up to speed on it, and they're going to call us on it, and we open up just unnecessary liability if we're not right there at the top of all those rules and regulations, on top of all the proper procedures, because certainly the public is. So with the interest in real estate auctions and the amount of money, whether it be for whether it's a $6,000 house or a $6 million house, the same rules apply. And so we need to be up on all this if we're in the real estate auction business. Curtis, I'll turn it over to you.
Okay, Mike, thank you so much. Thank you for your insight and knowledge. And at this time, ladies and gentlemen, we have, as we mentioned earlier, we'll open the floor now for your questions from iSeries attendees who may have questions after they listen to Mike's presentation there. We did have a couple of questions come in during the presentation. Mike, I think we'll start here. What major court cases do you envision involving real estate at auction in the next 5 years? I know you talked about several past cases that have helped shape where we are today in this industry and how that relates to real estate. But what do you see maybe coming up on the horizon?
Great question, Curtis. And I think for sure we're going to see the next large cases. I don't think we're going to see, incidentally, any at the Supreme Court level probably ever again, but we're going to see state as high as state Supreme Courts take on cases involving online real estate auctions. Whether having pre-bidding constitutes opening the auction prior to the start of a live auction, if we're doing bidding prior to, whether the same rules apply once the auction's underway. I think that's pretty well established now, but I just think there's going to be, I think probably all the next 2, 3, 4, or 5 big cases are going to involve the internet, online, bidders from a distance, and lastly, we're getting bidders out of the country. We didn't have too many bidders in 1950 bidding from Korea or Japan or China or elsewhere. Today we do, and I don't doubt there's going to be a case involving foreign transactions and contractual obligations and things like that.
Sure, and that brings a really good point, and actually leads right into the next question that I had lined up here from our folks that are listening. When it comes to issues in today's market, including online, in the topic of pre-bidding, with pre-bidding for an online real estate auction, when is an auction considered open? Has the internet changed that game?
Well, the practice of selling real estate at auction is often includes offering some sort of bids prior to. So maybe the auction is listed 10 days or 15 days or longer before the actual live auction. Bidders are allowed to place bids prior to, and then those bids are used to open the auction 15 days later at the live auction, maybe. And there's a number of ways it can be done, but that's one common way. The UCC 2328 says that the auction's on when there has been a calling for bids, And so the question, it's a great question, is the pre-bidding calling for bids? It would suggest to me it is. We've got an online platform that allows for pre-bidding. It suggests that you can place a bid. Does that constitute calling for bids? I suspect so. And so then, not so much in the reserve format, but in the without reserve format, can that property be withdrawn once a bid is placed within a reasonable time? And per state law, it cannot be. But some auctioneers maybe look at it and say, well, I haven't really started the auction yet. These are just pre-bids. And so I think wording, terms, conditions, disclosures all become a part of that. It's going to be interesting to see how the courts handle that and whether they affect how those pre-bids are managed.
Okay, and Brent wants to know, in the real estate setting, as an auction professional moving into that side of things, what are some more of the most common mistakes that an auction professional may make in a real estate auction?
Well, mistakes that I can certainly comment about mistakes auctioneers have made. Two come to mind right away. Opening an absolute auction, commencing or calling for bids on an absolute auction without reserve auction with a small, modest, or virtually non-existent crowd there, basing that on maybe you've only got 2 bidders standing there or 3 bidders standing there or 4. You don't have to start an absolute auction, but auctioneers may be under the impression if it's selling absolute, I have to start the auction, it has to sell. You can withdraw the property prior to putting it up in a with or without reserve auction. So I see that mistake. The other thing I see auctioneers getting into some trouble with, and I've done some consulting with attorneys and auctioneers on this, whether or not you can control the bid increments in an absolute auction or a without reserve auction? Or similarly, can you control or limit the size, not take less than $1,000 bid at a auction advertised as an auction advertised selling to the highest bidder? And there's been more than one case where courts have said, well, if you're selling it to the high bidder, then you can't refuse a higher bid. And I guess in the abstract that could mean 1 penny more. You'd have to take that bid. Even if it was with reserve but selling to the high bidder, it might suggest you have to take that next higher bid. And I see auctioneers struggling with that as well.
Sure. And then we've got time for a final question here, and this one from Jason. Is it possible to comment, or can you comment on whether a real estate broker license might be needed for real estate auctions?
It's all by state, Jason. Every state regulates in a different fashion. There are states, the state I'm in, Ohio, requires that you have a real estate license to do bid calling at a real estate auction and be involved in the balance of it, the closing, terms, signing the contract, etc. But I travel one state west to Indiana, and they don't require the bid caller to have any sort of real estate license at all. Now they do require, Indiana does require the auctioneer to then, if they step off the block, as they say, to then have a real estate license. So most states are probably one or the other of those varieties. Either they require a real estate license overall, or they at least require a real estate license to conduct the contract signing, closing, etc., post-auction activities.
Excellent. Okay, everyone, that'll wrap up the Q&A portion of today's event. Thank you to all of those who submitted questions. We apologize if we didn't get to yours. We do have the ability, and we are collecting all of the questions, and we'll forward those to Mike so that if he has an opportunity to answer those after the fact, he can certainly do so. It's now time for you to give us your feedback on today's session. Please see the poll on your screen and answer the questions as they appear. They do move fairly quickly as we get to the end of our webinar here today, so please answer as swiftly as you're able. So your first question of 3, and you should be able to see that now. If you'd go ahead and answer that question for us, please. We'll let that stay open for about 10 seconds or so. All right, a couple of more answers are coming in here. We'll go ahead and close that one down, and we'll move to the second question. And the second question coming up now, I found the 30-minute time length to be a good fit for my schedule, so we'll go ahead and launch that one for you, and you'll be able to answer that as well. We'll keep that open for a few seconds here. A few more seconds. We do appreciate you all taking the time to answer these questions. It helps us move forward through the webinar as we go through the coming months here. About 5 more seconds, and we'll go ahead and close that one. And we do have a last question. I am interested in attending another iSeries session, so we'll go ahead and launch that and have you answer that for us as well. And we'll keep that open for about 5 more seconds here. Again, thank you for participating. It really does help us plan as we move forward through the iSeries. And we'll go ahead and close that one. Wanted to say thank you to Mike Brantley today for taking part with us and presenting on his information within the series today. And thank you for taking part in the survey as well. So before we end today's session, we did want to please note that you can build off of what you've heard in today's iSeries session. The National Auctioneers Association's Designation Academy, featuring a completely revamped AARE curriculum, will be taking place December 7th through the 13th at the Bally's Hotel and Casino in Las Vegas. Among the courses offered, you'll be able to take the AARE designation course under Mike's direction, along with having the ability to expand your network with auction professionals, having the ability to pick up your education and having that ability to network and build your own personal and professional relationships is an opportunity we certainly at NAA certainly encourage you to take advantage of. So you can register for the 2014 NAA Designation Academy by visiting auctioneers.org/events or by calling 913-563-5432. And again, you can see that number on the screen, but again, it's 913-563-5432. And finally, before we wrap up here today, please be sure to join us again for the next iSeries session on Wednesday, January 7th, as we dive into Salesforce development. We will send information to you on this event in the near future and over the coming weeks. We do certainly, again, thank you so much for taking part in the NAA iSeries, and again, thank you to Mike Brandley. That does conclude today's webinar, and remember, the NAA iSeries always and will always exist because it's about you. Thanks much, and have a good day.